Hello, my name is Suzy Hershman. I work for MyDeposits, which is part of the Hamilton Fraser group of companies. My background was I went and did a law degree as a mature student. I went to the University of Westminster in London, and then I followed it up with the legal practice course at the College of Law, thinking that I might want to become a solicitor. But the timing, as always, was off, and I hit 2008 recession. And I was introduced to Eddie and Sean. Eddie is the CEO of Hamilton Fraser, and Sean was working here at the company, and actually Sean was the one who interviewed me, and agreed that we could work well together. And we all went off to the Chartered Institute of Arbitration and did an adjudication course with others at the time, and we started doing more and more adjudications in-house. Well, it developed in terms of bringing more and more in-house, bringing on a team of people, so I was training them as well as doing adjudications. The team got as big as 15 at one point. It's slightly reduced down now, but from following up from starting as an adjudicator, building a team, managing the team, I then started also creating content for the website, writing case studies, guides, and then as the company has grown and evolved as well, I became head of adjudication, going out and training letting agents, developing workshops, being asked to attend speaking events, writing case studies, working with other departments. So as the PRS, the Property Redress Scheme, came into being, I'm now helping out with their complaints, writing some of their guidance, having an overview on their content on the website. So it's quite varied in terms of knowledge across the business. Tenancy deposit protection has been around since 2007, so by law, anybody who takes a deposit from a tenant, landlord or agent under an assured short-hold tenancy has to protect that deposit. It's a valuable tool to have in your back pocket for the end of the tenancy. If the tenant owes any rent or has done any damage to that property, there is a pool of money there to be used, but evidence is key to any of that, to having any claim of that, because what some people don't always understand is the default position is that that deposit, no matter who is holding it, is the tenant's money. So evidence becomes key in proving any entitlement to hold it at the end. Yeah, by law now you have to have a tenancy agreement, a deposit clause in that tenancy agreement explaining that it is protected by one of the schemes, and there are 3. And under what circumstances it can be kept back by the landlord at the end of the tenancy. I think taking a deposit is a very easy way to deal with the end of tenancy issues. No deposit schemes, nil deposit schemes, there's a few different names for these schemes that are very, very new to the market, and they have yet to be tried and tested. So I don't really want to go into those too much at this stage. I think another 6 months, 8 months, a year down the line, we will understand a little bit more about them. But there are potential pitfalls with these no deposit schemes, whereas taking a deposit and protecting it gives you that cushion right from the beginning of the tenancy. You haven't got to worry about making a claim at the end, chasing a tenant for the money that you might not even be able to contact him. So there's lots of these different pitfalls to think about when you look at these other schemes that are coming. I'm not going to say they don't work because we don't know yet, but I think it's a bit of a watch and wait situation. I come from a tenancy deposit scheme, so I don't want to appear biased because, as I say, we don't know yet whether these other schemes are going to work and what the potential benefits of them are. I think taking a deposit is still the best way and the easiest way to deal with end of tenancy disputes and deductions. Because at the moment, if there are no, landlords and tenants often agree to deductions at the end of the tenancy. We only see maybe a maximum of 3% of all our protections go to a dispute. So you've got to think in 97% of cases there is either no deduction or agreed deductions and no dispute. So it means that the end of the tenancy is done, dusted, everyone moves on. If you've got these no deposit schemes, there's a policy in place. The policy has to be dealt with. And I think it may, but it remains to be seen, create more work for everybody than the current system of taking a deposit. I think, well, I know the most common issue is cleaning. And it's always been the most common issue. And when I do a lot of training, we talk a lot about cleaning. After that, you've got your damage, which might include redecoration, which is a very common one. There's a lot of lack of understanding on where does fair wear and tear stop and start. So we're looking at scuff marks maybe only being wear and tear, scratches, dents, things like that being more than. But I don't want to go into too much of that detail at this point. I think what's really important, a top tip for landlords right from the beginning of the tenancy, is to have a good inventory. And even today I'm seeing inventories that don't appreciate there is a difference between condition and cleanliness. So a lot of agents using their own inventories, a lot of landlords doing their own inventories, saying something that is in good condition at the beginning and then saying it's not clean at the end. They're two different things. And the really easiest top tip way of remembering that is to think that fair wear and tear will apply to anything with a condition, and fair wear and tear will not apply to anything in relation to cleanliness. So if a property is given out clean to a good domestic standard, it needs to be returned cleaned to a good domestic standard, no matter how long the tenancy is, whether it's 6 months or 6 years. I think having an inventory is very often okay. So I've just done a case where there was an inventory appended to the tenancy agreement, which was actually fantastic practice. So that's a really good tip. If you've got your tenancy agreement and your inventory almost all in one and it's signed for by the tenant, I think that's a fantastic way for landlords to keep everything together at the beginning of a tenancy. Where this landlord fell down was that his inventory was just a list of the contents without a schedule of condition. So, and that's where that is critical to your starting point, because every dispute starts at the beginning of a tenancy. The other mistake that was made on this particular case was that the landlord was clever in taking photographs that were digitally dated for the start of the tenancy to go with the list of contents. However, they had not thought to take pictures of every room. They had relied on an estate agent's brochure of the property, which was undated. So a lot of little things that didn't tie up with the beginning of the tenancy, and I couldn't verify the condition of that whole property because the photos weren't reflective of each area of the property. So when the landlord came to make claims at the end, there were discrepancies with what I could compare from start to end. So taking photographs at the beginning, if that's the way you want to do it, is fine, but you need to follow the property round in some sort of order. So if there is a dispute and it does go to an adjudicator, or you want to negotiate with your tenant, you have to be able to prove what it was like at the start and that the area relates to something you can take a good picture of at the end. And very often landlords haven't grasped that. Obviously, I'm only talking about the disputes that I see, so a lot of landlords have grasped it. But maybe the newer landlords or landlords that have never had a dispute before learn the hard way, unfortunately. So there's a lot of top tips you can give people. We have a lot on our website, but they have to want to go onto the website. They will have to want to learn rather than think, okay, that's good enough. Yes, it's www.mydeposits.co.uk, and we have a nice resources tab on the website.